Peace and love. It's your boy Kadeem Hananiah Mishael, and I'm coming back again with part two of the first bill of particulars as it relates to the status of being Black, right? It should be well understood by this point that Black has no status in law. And why is law even important? Because law governs all events, right? Universal law, the law of cause and effect, the law of polarity, you know, there's so many laws, right? You got God's laws, you got man's laws, you know. So moving forward, um, sorry about that. Moving forward, we have some work to finish. So again, rights and privileges, right? Of quote unquote American citizens. You're the true Aboriginal American, and you are entitled to an estate. You are entitled to a nationality. Again, the African American brand, Indian, Black, colored, those are all brands. None of those are nationalities, which means you have no protections under a nation's treaty with another nation. In this case, between Aboriginal Americans, um, we have treaties with various nations. Anybody who came here to do business in the land of North America, also known as the land of the Moors, Northwest of Mexam, we have treaties. Okay. Because we were already here. When Christopher Columbus came here, again, they were on a conquest to destroy and murder and commit genocide against the indigenous inhabitants here, to remove them from their land so that they can come here and do business. But what the people of Moorish descent need to understand is we gave the Europeans the right to do business here on our land by treaty. Because again, it was countless wars between the Moorish nations and the European powers. Okay. This is what's been going on throughout history for a very long time. Because the Moors once ruled the world once again. And there's evidence of that in Europe. There's evidence in that in the Vatican, and a ton of libraries all around the world. Even the Library of Congress over here, they have records of, you know, the Aboriginal peoples inhabiting this continent prior to the invasions, right? Prior to the diseases, right? So we had to create treaties to end the wars. But we're still at war. We're still at war. they're not upholding their bargain of the treaties. And one of the reasons for that is because the people don't understand that the treaties are the supreme law of the land, and that they actually supersede the Constitution. So when we talk about the rights and privileges of Black people, quote unquote, we must refer back to the supreme law of the land. Okay. So a treaty is in its nature a contract that must be well understood, because the contract makes the law, right? The contract makes the law, the agreement between the parties. That's what makes the law. Okay, between two nations. So again, what is your nationality, right? For you to even have rights protected by a treaty. So a contract between two nations, not a legislative act. It supersedes a legislative act. I don't know why it's not letting me. But y'all get the point, right? It does not generally affect of itself the object to be accomplished, especially so far as its operation is infra-territorial, but is carried into execution, by the sovereign power of the respective parties to the instrument. So we're going to refer to one treaty in this bill, the longest standing treaty with the United States of America, namely the Treaty of Peace and Friendship between Morocco and the United States of 1787 and 1836. And we're going to dive a little deep today into that treaty and how, as a Black person, you'll see that the treaty is very specific as to who the respective parties are. And if you're claiming to be something outside of one of those respective parties, then you have no interest in the treaty. You have no rights to the treaty, right? So when we're talking about the sovereign power, all sovereignty comes from the creator. The creator is the ultimate sovereign, right? We are a reflection of the sovereign. We were made in the image of the sovereign. And as the original people of the planet, we have been bestowed, we have had trusteeship bestowed upon us by the creator. Because by being the first people on the planet, we have the responsibility and the duty to protect our planet, our home, right? Our temporary home, right? So the sovereign power that we have is through the Almighty God. And in the treaties, most of them, if not all of them, they all open up in the name of God. And we'll see proof of that in a minute in just one example. Right? But we must carry into execution the articles of the treaty that apply to us in our civil dealings. Okay, but how can you do that when you're civilly dead. It's not possible. You don't even exist in law. Right? So, carried into execution by the sovereign power of the respective parties to the instrument. In the United States, a different principle is established. Our Constitution declares a treaty to be the law of the land. It is consequently to be regarded in courts of justice as equivalent to an act of the legislature. Whenever it operates whenever it operates of itself without the aid of any legislative provision. But when the terms of the stipulation import a contract, when either of the parties engage to perform a particular act, the treaty addresses itself to the political, not the judicial department. And the legislature must execute the contract before it can become a rule for the court. By the stipulations of a treaty are to be understood its language and apparent intention manifested in the instrument, with a reference to the contracting parties, the subject matter, and the persons on whom it is to operate. Now, here's another secret, hidden piece of information that they don't like to tell people. The United States of America, this so-called country, was not founded upon Christianity. And we have proof of that via the Treaty of Tripoli, which was signed in 1796. Right? Just getting started, y'all. Bear with me. Bear with me. So, there is a firm and perpetual peace and friendship between the United States of America and the Bay. The enforcers of the law obey the law. Bay is one of our titles of nobility. Bay is one of the appellations of our foremothers and forefathers that are recognized in law. United States of America and the Bay and subjects of Tripoli of Barbary, made by the free consent of both parties and guaranteed by the most potent Dey and Regency of Algiers. Now check this out. Check this out, y'all. As the government of the United States of America is not in any sense founded on the Christian religion, as it has in itself no character of enmity against the laws, religion, or tranquility of Muslim men, and as the said states never have entered into any war or act of hostility against any Mohammedan nation. It is declared by the parties that no pretext arising from religious opinions shall ever produce an interruption of the harmony existing between the two countries. So now you know. United States of America is not in any sense founded on the Christian religion. And Now I'm sure you have an idea of how we, the people, we, the people, are the ones with the authority. One moment. We, the people, are the ones with the authority because we are the ones who established government. In fact, government starts with family. The family structure is government. Is where government actually derives from, right? So let's clear up this Moorish thing, right? Why are we Moors, right? What is this thing about being Moorish or being of Moorish descent instead of being black? I'm going to pull up a resource here. Might want to get this book, Consecrated Talisman. Great piece of work here. For those of you who are interested in really learning about our history, let me find just a moment, y'all. So one moment, let me find this, y'all. Wow. It is crazy when you haven't reviewed some stuff in a while and you see some stuff that really stands out. All right, let's get back to the subject matter. Let's get to the subject matter. Okay, so the geopolitical significance and linguistic diagnosis of the nomen name Moor according to Euro-American Anglese usage. Though perhaps one of the most crucial disciplines of this publication, we have by divine instruction chosen to bestow light, science, and wisdom on the grammatical topic in question of this word Moor and its English usage to better comprehend the trenchant placement and rank amidst the conscripted geopolitical commercial divisions of the earth, who would by the greatest acts of prestidigitation and a German silver artifice referred to themselves as nations. However, the people or inhabitants of these lands simultaneously allowing themselves to be identified by designative soil nomenclature, e.g., Syrian equating to Syria, Egyptian Egyptian to Egypt, etc., rather than the holy fluid of man or the manifest her or himself, it est by blood and free national name. How in truth does this knowledge factor in, or even for that part, take precedence above any other business of these would-be nations, the people thereof and their official heads? Let us ask ourselves, while we give very strong consideration to the aforementioned, what exactly does this mean to Moors in general, and of course, more specifically, for Moorish Americans? We have so concluded that this question may be best answered through an intense scientific investigation and linguistic analysis of the said Euro-American English interpretation or definition of moral. Shall we commence? Very well then. In viewing the overwhelming documentary evidence we see on page 469 of Webster's Encyclopedia, Dictionary, 1942 AC, Moor is defined as pertaining to the Moors or Saracens. Great. So now we turn to page 643 of the same publication, and we see that Saracen, Latin Saracenus, Greek Sarakinos, Arabic Sharhun, is defined as Orientals, Easterners, Asiatics, also an Arabian or very important other, also an Arabian or very important other Muslim, Mohammedan, or more of the early proselytizing period by medieval writers. Page 301 of the New Encyclopedia Britannica, Micropedia, Ready Reference, 15th edition, number 8, Moor in the English usage is defined as a term denoting any Muslim in general, as in the case of the Moors of Sri Lanka or of the Philippines. The word naturally deriving from the Moorish Latin mori. We find confirmation of this when we return to the Webster's Encyclopedia Dictionary 1942 for the definition of Turk, which states a native or inhabitant of Turkey, hence a Mohammedan, Moor. This interpretive English denotation is corroborated by author Budget Meakin in his 1902 AC publication, The Moors, a comprehensive description, showing that Moor comes from the Moabite, Phoenician, Canaanite, and Hebrew Mahor. In addition, he also points out that Moors are not only Mohammedans or Muslim in the context of the religion Islamism, but that all Orientals are Moors, of whom were also called Mormon. And further, that this description metaphysically was of those people referred to as Native American or North American tribes Indians. As we search for further assent, we find in the Oxford English Dictionary volume, 6, L through M, 1933 AC, Moor in English usage is thus defined, beginning with the first 7 forms. Mar, M-A-U-R, more, M-O-R-E, more, M-O-U-R-E, more, M-O-W-R-E, Maury, M-A-U-R-E, and then more, M-O-O-R-E, right? And then you have classical Latin, Morus. You have medieval vulgar Latin, Moros. You have Greek, Mopos, Spanish, Portuguese, and Italian, Moro. Middle Dutch, more or mower. You have Dutch, more. You have Old High German, more, mori, etc., etc. And notice how in the word, even in the word American itself, the first word in it is a more, a mer, American, a Moroccan, a Moroccan, right? So, what else it says? So what does all of this mean in relation to Moorish Americans, etc.? If we are to truly understand the Syros-Mohammedan blood tie and its geopolitical significance in the lawful matter of national identification, we must therefore give a due preponderance of the empirical evidence thus gathered in our scientific investigation and linguistic analysis of the English usage of Moor, and affixly that Mohammedan and Moor are irrefutable are irrefutably synonymous in meaning. Accordingly, providing the sound legal basis for a national distinction between those persons of Mohammedan countries' lands who are in fact Mohammedan more. But sadly, for one of the million reasons, results being that these same persons are by name, as earlier demonstrated, subjects of those lands. But as stated, they are nonetheless Moors of Moorish lands. Hence, what this means for Moorish Americans in the general sense, corresponding to the English usage, is that those Moorish Mohammedan governments of Moorish lands who have engaged in international relations treaties with the United States by treaty still enforce, be it peace and friendship, general commerce, income tax treaties, etc., making treaty provisions for various immunities, exemptions, and the like of would-be foreign nationals, e.g. Bangladeshian, Cameroonian, Egyptian, Jordanian, Iranian, Lebanese, Saudi Arabian, Mauritanian, Syrian, etc., are, as many of the treaties themselves expressly identify these people as Mohammedan or Moors. Therefore, due to this true national identification by blood relation, those provisional immunities extend to Mohammedans worldwide. How so? As long as the Moorish national Mohammedan of any of these lands does not use the commercial name of these lands to identify themselves, they cannot be relegated to the subjective nomenclature of Moroccan, Jordanian, etc. This is all based on their European and Euro-American English definition. Okay. And also this last note, from a federal depository of New York State in the Handbook of North American Indians, page 290, United States Government Printing Office, Washington, D.C., 20402, stock number 047-000-00351-2, copyright by Smithsonian Institute, Library of Congress. It states that among the reputed ancestors of Aboriginal American Indian population, natives, are Moors and Turks. So, I hope that gave some insight to kind of clear up a little bit as to what our national identification is. Now, I know a lot of people may not agree with the whole idea of being associated with Muhammad, Prophet Muhammad, right, and being Islamic, and that's totally fine. But this is a part of the reason why we're committing treason and why we're being treated as exiles in our own land, because we don't honor the names of our mothers and our fathers, right? We've been led astray to run after, to idolize the gods of the Europeans, right? So moving further, so the Treaty of Morocco, the Treaty of Peace between Morocco and the United States, the longest standing treaty with the United States, was originally written in Arabic. I got proof of that right here. It was originally written in Arabic. And Arabic was the international language of trade. And again, we were the navigators all over the world, spreading peace, Islam throughout the world. But some of the Moors fell in their lower self, right? Some of us became subjects of the lower self, the lower nature of man. and began doing things outside of the law, not limited to slavery, killing, raping. You know, our people are not innocent, okay? So I just want to clear that up as well. But just to give you guys proof that the original treaty between the Moroccans, the Moorish Empire, and the United States, it was originally written in Arabic. Now, I don't understand Arabic, to be honest with you. I will be learning. But yeah, I just want to show you that as well real quick. Before we get into the treaty, the contract between the two nations, the two governments, right? Because it's a dual government. And I'm gonna show you guys something. Hold on. I'll show you how the dual government again. Show y'all the dual government, man. It's two governments here, man. Okay. It's two governments here. And let me help you get familiar. So, you got two governments. You got two seals on the back of the dollar bills representing two governments, two different nations. On the original right side is the Moors, the Moabites. Okay, and then the other side is the Albions, the Europeans. Okay. And the dual governments. Okay. So moving further, where a treaty is executed in two languages, each the language of the respective contracting parties, both parts of the treaty are originals and both are intended to convey the same meaning. Where a treaty has been ratified according to the provisions of the Constitution, it becomes the law of the land, and it is perfectly immaterial whether or not the persons who signed it did or did not transcend their instructions. A treaty does not necessarily annul prior statutes if there is no interference with them. The stipulations in a treaty between the United States and a foreign power are paramount to the provisions of the Constitution of a particular state or the Confederacy. Okay, because there was a Confederacy too, called the Iroquois Confederacy. These are the so-called American Indians, Moors, that had government established here prior to even the Constitution for the United States of America. So, Iroquois, Quois Confederacy, and this is what they call the Five Nations, or the five civilized tribes: the Els, the Bays, the Als, the Days, and the Alis. Okay, these are your family. So, the Iroquois Confederacy, okay, also called the Five Nations or Six Nations Confederation of Five, later six Indian tribes, etc., etc. The Great Law of Peace, the Great Law of Islam, okay, the Great Law of Islam, because peace, that's what Islam means. The Great Law of Peace was a constitution that established a democracy between five Iroquois-speaking tribes, etc., etc., etc. Okay. The confederation of the original 13 colonies into one republic was influenced by the political system developed by the Iroquois Confederacy. as were many of the democratic principles which were incorporated into the Constitution itself. Okay. So we have large influence. Okay. Now, moving further. All right. A judgment of a state court where jurisdiction was acquired, not by the common law, but by a statute of a state, which, before the rendition of the judgment, had been virtually repealed by the adoption of a treaty, was voidable, not void. So, the treaty goes into the operation from the date of the signature, if no other period is agreed upon between the parties. So, check this out. Treaty of Peace and Friendship. And we're going to have to do a part 3 of this because this video is going to be very long if I stretch this out. So to all persons to whom these presents shall come or be made known, whereas the United States of America and Congress assembled by their commission, they were commissioned. They were given authority by their commission, bearing date the 12th day of May, 1784, thought proper to constitute John Adams, Benjamin Franklin, and Thomas Jefferson, their ministers plenipotentiary, giving to them or a majority of them full powers, giving to them or a majority of them full powers to confer, treat, and negotiate with the ambassador, minister, or commissioner of His Majesty the Emperor of Morocco concerning a treaty of amity and commerce, to make and receive propositions for such treaty, and to conclude and sign the same, transmitting it to the United States and Congress assembled for their final ratification, and by one other commission, bearing date the 11th day of March 1785, did further empower the said ministers plenipotentiary or a majority of them by writing under their hands and seals to appoint such agent in the said business as they might think proper, with authority under the direction and instructions of the said ministers, to commence and prosecute the said negotiations and conferences for the said treaty, provided that the said treaty would be signed by the said ministers, etc., 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 etc. Okay, in the name of Almighty God, this is a treaty of peace and friendship established between us and the United States of America, which is confirmed, and which we have ordered to be written in this book and sealed with our royal seal at our court of Morocco on the 25th day of the blessed month of Shaban, in the year 1200, trusting in God, it will remain permanent. Okay. So, Article 1. We declare that both parties have agreed that this treaty, consisting of 25 articles, shall be inserted in this book and delivered to the Honorable Thomas Barclay, the agent of the United States, now at our court, with whose approbation it has been made, and who is duly authorized on their part to treat with us concerning all the matters contained therein. If either of the parties shall be at war, we are currently at war, okay, with the European nations, because they're waging war against us through vaccines, through the GMO food, through the pollution of the air, pollution of our water, locking us up for victimless crimes, kidnapping our women, removing the children from the homes, kidnapping their babies, CPS, and the list goes on. If either of the parties shall be at war with any nation, but guess what? If you're Black, you're not a part of a nation. You don't have a nationality. So this doesn't apply to you. But if you are in honor of your mothers and your fathers, your forefathers and your foremothers, who were lawfully known as Moors, then now you can start to use the treaties to protect yourself. It's just that simple. If either of the parties shall be at war with any nation, whatever, and take a prize, take any property, because that's the prize, and you're the prize. As a matter of fact, we got to pull up prize. Take a prize belonging to that nation, belonging to that nationality. Oh, you found one. That's good. That's good. So, prize. What is the prize? What does prize mean? Oh, thank you. What is the prize? What is the prize? You are the prize. So let's find a definition so we can make it make sense, right? What is the prize? What is the prize? So, prize. It says anything offered as a reward of contest, a reward offered to the other person who, among several persons or among the public at large, shall first or best perform a certain undertaking or accomplish certain conditions. Now, we're going to talk about admiralty law because that's what this is applicable to. The treaties between the empire and the United States of America was dealing with amity and commerce and dealing with the laws of the seas. This is why we must become alive from being dead and lost at sea, because we are at sea, right? Commerce is heavily influenced by the element of water. Okay. Notice they'll freeze your assets or they will liquidate them. Okay. They will liquidate your assets at 33 degrees and freeze your assets at 32 degrees. If you know, you know. So in admiralty law, a vessel or cargo, your body is a vessel, and anything attached to your body is a vessel. Okay. An extension of the vessel. Right? A vessel or cargo belonging to one of two belligerent powers apprehended or forcibly captured at sea. You came out of your mother's waters, out of her seas, onto the land, and you dry docked. You came on the land, right? You docked on the land. Right? And the doctor, he captured you and he registered you and he gave you a name in the registry of the corporate state where the birth took place. And that actually represents property. Okay? Because you came out of the waters onto the dock by the doctor who was indoctrinated, and you were stripped of all of your entitlement rights right then and there when they separated the heir from the mother and started to perform their operations, cutting their placenta, all of that type of stuff, right? So, captured at sea by a war vessel or privateer of the other belligerent, and claimed as enemy's property. And claimed as enemy's property. And therefore liable to approbation and condemnation under the laws of war. This is in admiralty law, the definition of prize. The apprehension and detention at sea of a ship or other vessel by authority of a belligerent power, either with the design of appropriating it with the goods and effects it contains, or with that of becoming master of the whole or a part of its cargo. Okay, goods taken on land from a public enemy are called booty. And the distinction between prize and booty consists in this, that the former is taken at sea and the latter on land. Oh my gosh. If you know, you know. All right. So take a prize belonging to that nation, and there shall be found on board subjects or effects belonging to either of the parties. The subjects shall be set at liberty, and the effects returned to the owners. So your property must be restored. Your property must be returned to you. Your rights must be restored, I meant to say. And your property returned to you. Your subjects is anybody who's subject to your jurisdiction, under your nationality, under your nation. So if you have people around you and they're on board with you and you're the commander, they would quote unquote be considered your subjects. So they shall be set at liberty right along with you, and any effects returned to the owners. And if any goods belonging to any nation with whom either of the parties shall be at war shall be loaded on vessels belonging to the other party, they shall pass free and unmolested, without any attempt being made to take or detain them. So there's your diplomatic immunity right there. There's your national immunity right there. There's your sovereign immunity right there. You shall pass free and unmolested, without any attempt being made to take or detain you. Your subjects shall be set at liberty, and the effects return to the owners, if we shall find on board any subjects or effects belonging to either or. So it's vice versa. Law of comity. So what applies to us also applies to them in the treaty. Article 3, what's that for? A signal or pass shall be given to all vessels belonging to both parties, by which they are to be known when they meet at sea. Now, this directly correlates to what you call due process of law. And the first element of due process of law being notice. You have to give notice. You have to give a signal or a pass by which you are to be known when you meet at sea, on the seas. Okay, when you meet these people, whether it's via affidavit delivered to their agent, or you have your flags, your flag, because under the law of flags, when you raise your flag or you fly your colors, that's you giving a signal. Okay, that's you letting all persons, all concerned persons, as you giving all concerned persons notice of the treaty obligations. Okay, especially if you're in the United States of America. So, and if the commander of a ship of war of either party shall have other ships under his convoy, the declaration of the commander shall alone be sufficient to exempt any of them from examination. So you're the commander. Your vessel, your U.S. citizen person, corporation, is a ship of war. Okay. And it is under your convoy. So any declaration made by you in your proper person shall alone be sufficient to exempt you from examination, i.e. search and seizure. Fourth Amendment. Your Fourth Amendment rights is protected under Article 4 of the treaty. But again, you have to give the signal or pass. And the pass is also known as a passport. Right? Because we're dealing with the ports. Article 5. If either of the parties shall be at war and shall meet a vessel at sea belonging to the other, it is agreed that if an examination is to be made, it shall be done by sending a boat with 2 or 3 men only. And if any gun shall be fired and injury done without reason, the offending party shall make good all damages. So any injury done without reason doesn't have to be physical. You have the right to make good all damages. You have the right to redress. You have the right to remedy. And we're going to pick up on a part 3 of this because this is going to be extremely long. I need some water. Truth, I get dry on all them something there. So, I go soon upon part 3, is it? So, don't forget, like, share, and subscribe. Sorry. Don't forget to subscribe to the channel. I'm going to be doing this a lot often, like I said in the first video. And study, y'all. Study, study, study. Because that's where the enlightenment is going to come. When you study to show yourself approved. All right. Once again, it's your boy Kadeem, Hananiah Mishael. Peace and love. And I look forward to seeing you guys on the next video. Asheo.